in Karen Read's multiple cases now. They were arguing in court in Massachusetts over that mistaken, inadvertent email reply button she hit, sending an email to opposing attorneys. But in the hearing, did someone misquote the law? And in a second hearing the same week in Karen Read's cases, they're still not giving Karen her phone back. Why not?
You lost. And you know what you did.
Oh, Yolie Medina, it's been 8 months since Karen Read was found not guilty of all major criminal charges brought against her. But the civil cases are just blowing up. This is About the Law. I'm attorney Andrew Myers. With me is co-host Yolie Medina from California. How are you, Yolie?
I'm fine. How are you?
I'm good. Well, you never have to look for something to cover in these podcasts when it comes to the Karen Read case, do you?
My God, it's crazy.
It really is. It just goes on and on and on. And let's jump right into it because there was a hearing. It was only a little bit less than a half hour, and we're going to edit it down a little bit. But there was a hearing in the Plymouth Superior Court with regard to the question of that email that Karen meant to send to her attorneys, but she hit the reply all button, but it went over to the attorneys for Paul O'Keefe and the family, the ones that are suing her. So let's jump right into the hearing. And it starts out with the court clerk, thankfully, identifying all the parties to the judge.
We have the parties present by way of Zoom. We have Attorney Diller for the plaintiff. We have Attorney Beaton for defendant CNC. We have Attorney Tang and Attorney Bell and Attorney Seligson, Attorney Rosenberg and Attorney Jackson present on behalf of Attorney Read. Defendant Read.
Good afternoon, counsel.
So even the court is confused here. So I don't feel bad. Don't you feel bad at all? But Karen Read has 6 attorneys. And one of them is Alan Jackson, who's all the way down there in the bottom right-hand corner. And he's there. Does he say anything in this hearing?
Attorney Diller and Attorney Seligson, a couple of general points. I purposely did not ask for you to provide me with the email in question so I could have the benefit of argument without knowing its content.
So that's the email when Karen hit the reply button and it went over to opposing counsel's office. I guess the judge wants to take a look at the law, and he spells out precisely in a second here what it is he's looking for, what the issues are, but he wanted to do it initially anyhow without the email. I thought that was interesting. Did you, Yolie?
Yeah, I thought it was interesting because I would think you would want to know what the email says so that you can apply it to the law, but I guess he's going to look at it afterwards and then apply it to the law. But it's kind of a blind argument here to the judge because the judge doesn't know what it was about, other than it's the same as her interrogatory response, which they sent to her that was about who unalived Mr. O'Keefe.
Yeah, you're right. Hang on.
However, to decide the issue of possible preclusion of any future use of the email for impeachment purposes, I think I will need to see the email. So I'll ask Attorney Seligson to provide to Clerk Donovan in a sealed envelope a copy of the email.
That's fine, Your Honor. We'll do that right away.
Okay, next, let's dispense with any back and forth on what the rules of professional conduct and claimed impropriety on the part of Attorney Diller. Attorney Seligson, I think your one Superior Court decision may not constitute sufficient case law for an attorney to understand their obligations under these unique circumstances.
So the judge does not want argument on the rules of professional responsibility that tell all of us what we can and can't do or should do in various circumstances. He doesn't want the attorneys going back and forth on that because the rules are the rules. The actual authority on the application of the rules would be our Board of Bar Overseers, the BBO in Massachusetts. And I think he wants to get past that and look at the actual facts and look at the actual law. That's my take on that.
Yeah, he doesn't want personal attacks or they were unethical or blah, 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 back and forth. He just wants the facts. What happened? What was the result? What did they do to try to resolve it?
I agree.
And let's all agree that the circumstances here are unique, just like they were in the charm case. We can all agree that inadvertent disclosures usually involve an attorney producing in discovery a document that should not have been sent out. In this case, the disclosure involves a client. And Attorney Diller, let's also be aware that I see no reason not to credit Attorney Seligsen's affidavit about blind copying his client being a one-time event.
Yeah, remember what that's all about? Attorney Diller representing the O'Keefes and said, well, he probably does this all the time. Well, Attorney Seligsen, who represents Canton, says, no, I don't. This is not my practice. And in fact, I've gone back and actually looked at my emails. And this is the first time I sent and bank all of the emails to Karen, letting her opening up the opportunity to do a reply all. So the judge is not having any of that. The judge is not having any of the
right.
O'Keefe's.
They were trying to say that, like insinuating that Karen Read is running the show. She's getting blind CC'd on everything and that she's the one telling the attorneys what to do and whatnot. And the judge wasn't going to have that.
Well, and the other thing is Diller is presuming a fact. I mean, when you go to court, you have facts. The light was red. The property boundary is right here. You know, you have facts. You don't assume stuff and then say, well, he probably does this all the time. That's just not something you do in court.
So what I see to be the questions here are, like charm, whether Ms. Reed has shown that she and her counsel took reasonable steps to preserve the confidentiality of the communication, and two, even if the answers to interrogatories in the inadvertently shared email don't provide plaintiffs any additional areas of impeachment, as suggested by Attorney Seligsen, what if future sworn statements of Ms. Reed in the email do?
I like this judge. I like the way he just couched the issues in a case like this that goes back over 3 years. In a case like this, where even in the civil case, there are so many issues. And even when the issues are narrowed down to what was developed in the motions and answers to the motions, you know, you go into court and you're not really sure. You read everything you can. You think about it. You conference it with your other attorneys. You go into court. Sometimes, I don't know how you feel, Yoli, sometimes my head is spinning, but this judge narrowed it down to 2 issues. What does he have to take a look at in making sure that either privilege was waived or it wasn't waived? And then number 2, you know, okay, should this be used in the context of whether the contents of the email should be allowed to be used, even if he decides that privilege has not been waived? Should the information in the email be allowed to be used in impeachment, considering what future statements might be made by Ken? And so he narrowed it down. I hope I said that correctly. Did I?
I think you did. I think you did.
All right. So now in the back of their minds, these attorneys can all go, okay, I read 1,000 cases. This is going to narrow it down to a couple of things I have to say, but did it really?
So let's try and tailor your arguments accordingly. So Attorney Seligsen, it's your motion, so I'll hear from you first.
Thank you, Your Honor. I appreciate the opportunity, and I think you synthesizing the issues really will cut to the chase here.
And I'm sorry that Mr. Seligsen is behind my About the Law logo. I don't think I have the technical capability to remove that at this point. So I apologize to my viewers and to Attorney Seligsen.
You referenced the charm case, Judge, and of all the cases that there are on inadvertent disclosure, and there are many in Massachusetts and there are many around the country, the charm case could not be more on point. Judge Fabricant faced the exact same issue.
It's probably the only case about a client inadvertent disclosure in Massachusetts, right?
That is correct, Your Honor. I was not able to find anything else where, as you said, it's normally the lawyer who includes something in a batch of documents, or an outside service has included something in a batch of documents, and the lawyer on the other side of the case gets that inadvertent disclosure. Here you have, in the advent of digital communications, you have an attorney in charm emailing opposing counsel, copying his co-counsel, blind copying his client. The client gets the communication, intending only to respond to his lawyer, writes back to everybody through a reply all. Judge Fabricant explains how that can happen to anybody. And what she does is she analyzes whether or not the lawyer and the client acted expeditiously. And she uses the word, used maximum effort to recognize the error, address the error, try and reclaim the communication because it was not a voluntary disclosure. In that case, Judge Fabricant granted the motion to strike that email, agreed that there was no waiver because the lawyer, even though he had done that once before, he had blind copied his client and the client had replied all. And even though the lawyer in that case simply asked the receiving lawyer to delete, destroy, and not use the email, did nothing more. Months later, that email is attached to an exhibit, to a motion for summary judgment opposition, and suddenly the lawyer thinks he needs to move to strike. So the email really wasn't reclaimed in the same way we have done, in stark contrast to that case and those facts. I've sworn in an affidavit which you credit, Your Honor, and I appreciate that because it's sworn under oath, and I stand by it. This is a one-time event, one-time incident where Ms. Reed was blind copied. Inadvertently, she replied to all, not intending for anyone but her counsel to get that reply. That squares with charm. Immediately, my colleague Aaron Rosenberg reached out to Mr. Diller. That was 39 minutes later.
So every effort was made by the Reed team once they realized the error. Every effort was made as immediately as possible to correct the error. And that's what you need to do. You got to admit we made a mistake. In this case, it was Karen Reed's alleged mistake. Immediately, less than an hour, they contact the O'Keefe attorneys and say, hey, guys, we made a mistake. Get rid of it, delete it, sequester it. But that's one of the first things you need to do.
Right.
Recognized there was a reply to all, recognized there was an inadvertent disclosure, demanded that it be deleted, destroyed, and not used. Mr. Diller said no, or didn't respond. I then reached out 44 minutes later, confirming, delete it, confirm you've deleted, don't use it, confirm you're not going to use it. Same thing, trying maximum effort to reclaim the privilege, to reclaim the inadvertent disclosure. We then had back and forth with Mr. Diller for a number of days. He refused to comply with us. We then served a motion. So we used the maximum effort. There was no pattern of behavior like this that you saw in Charm. There was maximum effort to reclaim it. So when you look at Judge Fabricant's analysis of the efforts by the client and her counsel, that we've done even more than Judge Fabricant allowed in granting the motion to strike. This is, by Attorney Diller, an opportunity which is evidenced in his opposition to our motion, Your Honor, where he actually goes so far as to make a sweeping allegation that he says that Ms. Reed and her team, in all likelihood, by her direction and or recommendation of counsel, has been blind copied on all email communications with opposing counsel since the outset of the lawsuit.
That's what I was talking about before. There are facts and manufactured facts, and that allegation by Attorney Diller on behalf of the O'Keefes was manufactured. You don't do that. You can't get into somebody else's head. There are legal arguments. I may not agree with them, but there are legal arguments to be made in this case, and we can talk about that in a few minutes, actually. But you don't say, Well, I know that Yolie Medina has a dartboard with my picture on it. I don't think she does, but it's just as ridiculous, in my view.
You never know.
Oh, thanks a lot, Yoli. I'm just going to make a real quick tip off topic. I think since the pandemic, we all should have learned how to use Zoom, but you never sit in front of a light source, whether it's a lamp that you're sitting in front of or a window. Yeah, we know you all have nice offices in Boston overlooking the city skyline. I had one of those at that time, but we don't need to see it. If you sit in front of a light source or a window, we're not going to see you. Enough.
That's right.
That is an outrageously inaccurate statement. It doesn't even comply with Rule 11, where a lawyer signs his name to pleadings and certifies that he has a good faith basis to make such a claim. What that means is Mr. Diller is trying to take facts that don't exist, create this narrative of recklessness, which does not exist. Ms. Reed was blind copied once, replied all once, and trying to fit that squarely in to get around what Judge Fabricant says in her opinion, which is lawyers should not take the opportunity to use something like this as an inadvertent disclosure and take advantage of that. Your Honor, for the same reasons in Charm, you should rule that there was no waiver of the attorney-client privilege here. This was not a voluntary waiver. This was an inadvertent disclosure. This fits squarely with Charm. We've done more than the lawyer in Charm did. We've acted faster than the lawyer in Charm did. We've proven there was no pattern like there was in Charm. And Judge Fabricant still understood the importance of the most sacred of privileges, the attorney-client privilege, and did not allow those facts to erode it. And we asked you to reach the same conclusion, Your Honor. Regarding the impeachment value of this email, we'll provide you the email in camera as you have ordered.
And so that first issue was attorney-client privilege waived by Karen Reed's mistaken hitting of reply all. It was inadvertent. She obviously didn't realize that it was going to the other attorney, so it was a mistake that she didn't know she was making. So that's argument one. Argument two, it's kind of hard to understand because what he's talking about is now the contents of the email, and they later say, well, the contents were, pretty much the same as her answered interrogatory. But the issue is, what if she says something in the future? Because we all know Ms. Reed has a penchant for talking to media. So that's why it's important. And Attorney Seligson on her behalf is now going to turn to that argument.
And you will see that it squarely fits with everything Ms. Reed has answered in the second interrogatory that was posed to her. So it has no impeachment value. The plaintiff's attorney was asked to return it. There's plenty of discussion in the rules of professional responsibility in the case law about returning an email that's been inadvertently disclosed. Judge Fabricant speaks about, to quote her, she says, as a matter of courtesy and in recognition of their own vulnerability, lawyers should avoid the temptation to seize opportunities arising from inadvertent disclosure. It's just, this should just end today. Mr. Diller should not be permitted to use it. He should not be permitted to disseminate it, and it should be destroyed. We've done everything we can to reclaim it, and I rest on those cases, Your Honor.
So you argued in your papers, and you just argued now about impeachment relative to the answer to interrogatory and the email. But what about in the future, if there was some statement under oath by your client?
Your Honor, there will not be a statement under oath that the email can be used for impeachment purposes. Mr. Diller
we hope not, because we're all, as lawyers, tell our clients that they can't commit perjury, but not all our clients listen to us all the time. At least
I like a judge who is sympathetic to the practicing attorney. For a while, there were some judges appointed to the bench that were appellate attorneys or who, were writers or who worked in the high ranks of insurance companies, and they don't understand what happens every day in a law practice. I don't know if you agree with me, Jolie, but I like the way this judge, understands, what really goes on in a law practice. You can advise your client all you want. Yeah, and I know that all attorneys that I know and deal with, before a deposition, give them the guidelines that the bar associations highly recommend that we give them. But do they always follow them? No, this judge knows that they don't. And so that's why this is an issue. Who knows what could come out in future depositions? You've certainly been surprised in depositions, haven't you?
Yeah. And, the everyday hand-holding, well, not every day, but the hand-holding that takes place when you're handling a case with a client and you have that relationship as opposed to an appellate attorney who just knows the case but doesn't really know the parties per se. So the day-to-day handling of your client and how the relationship that you have, sometimes it can get strained, and especially in a high-profile case like this. And clients sometimes want to do what they want to do. And, Karen Read was very vocal during her cases. And that was something that I thought was not good for her. But, she did what she wanted to do. It worked out in her favor in the criminal trial. So, yeah, this judge is sympathetic, and he knows this is a high-profile case, and he knows that Karen Read likes to talk.
And the depositions have not been taken, even though there are 41 of them to be held. The week before this hearing, it was disclosed there were 61, but really there were 20 duplicates, so there's really 41. But as of this date that we're recording this episode, not a single one has been taken, and he wasn't all that thrilled with that.
My clients didn't always listen to me. So just the possibility of that in the future.
I understand, but I think that answer will be very clear for Your Honor once you see what is in the email and you compare it with what is in the interrogatory answers. I have to tread lightly because I don't want to say anything about the email, but you will see that once you read the email and you compare it with the interrogatory answers, if there was something inconsistent with the interrogatory answers, then sure, then Mr. Diller can use that for impeachment purposes. But the email itself has no impeachment value once you look at it with the interrogatory answer. There have been 2 interrogatories served on Ms. Read. The second one asks her, and we suggested that to Mr. Diller because we were going back and forth about whether or not her first interrogatory answer he thought was needed clarification or expansion. So we suggested to him, ask another interrogatory about stating the basis for the affirmative defense in the answer to the complaint, which states somebody else was responsible for the death of John O'Keefe. In response to that interrogatory answer, we have, with Ms. Read, assisted her, and she has signed her interrogatory answer that is consistent with what's in that email. So there's no impeachment value. He can use the interrogatory answers. What we're trying to avoid is him making the argument that somehow she has waived the privilege and he can use the email. There's no basis for it. And I think the in-camera review will answer that question squarely for you, Judge.
Okay, thank you. Attorney
Thank you.
Diller?
Your Honor, thank you. I want to address first and foremost what was just raised, which is the reply brief. I think it's noteworthy that counsel for the defense did not file this motion under seal. In fact, they attached a reply brief that says verbatim, comparing this answer to the privilege communication demonstrates that there are no areas for impeachment unique to the privilege communication. And then they add as an attachment to that email the answer to interrogatory under oath statement signed by Karen Read, all of which, given what's happened in this case, has been picked up in the news and become part of the public domain.
I don't think the public domain has anything to do with the argument. I mean, you're arguing an issue that's been couched by the judge himself at the beginning of this hearing. So what the public thinks is totally irrelevant. I know you go home or the coffee shop and people talk, but that has nothing to do with this. So I really didn't understand making a big deal out of the fact that the attaching of the interrogatory answer disclosed the secrecy, because even if the substance was parallel, and I disagree with some other attorneys I've heard talking about this, even if the substance of the two documents was somewhat parallel or close, they're two different documents. They're just two different documents.
Well, yeah, exactly. But one thing I do want to say is that if the information that's in the email parrots what her interrogatory response says, then no harm, no foul.
Right.
But what Attorney Seligson wants to do is he wants the defense not to be able to, or the plaintiff not to be able to use it for the reason that he's going to infer or imply that Karen Read is the one telling her attorneys what to do. That's my take on it.
Yeah. And the other point I would make is, I hate to admit it, but I'm old enough to remember when interrogatories were actually filed with the court in Massachusetts. When I was a young law clerk, I could actually go to the court. No such thing as the internet back there. And the TV stations and radio stations and newspapers could have cared less. So it really wasn't public information. But I remember as a law clerk, if there was a case that we had nothing to do with, but we heard that it might have some information that was interesting to us, we could go to the court clerk's office and see the interrogatories and make a copy of them and take them back to the office. Those days are long gone because the courts have now said, no, we don't want you to file them under Superior Court rule. I forget the rule and I forget the exact date that it came in. It was well before the year 2000. No, we don't want you to file that stuff anymore. But in any event, I just didn't see making a big deal out of that. But all right.
The law's privilege is waived when its contents become public. Counsel, to the extent that there may have been a privileged communication in the email to which I did not disseminate, chose to put its contents directly into a public filing and attach the answer to interrogatory to which Attorney Seligson just communicated to you, stands for the same issues and the same facts are lying. Now, I appreciate that Your Honor wants to look at this in camera. I would say to you that I'm not really sure why we are here at this point, given that I understand why it was served. I did not disseminate it based on an agreement that I had with them, but I did point out case law why I believed that I could use it to impeach credibility, given that there were other statements that I believed to be inconsistent with that. And then I understand after I served my opposition why then it would be filed, but I didn't understand why there was no attempt by counsel to seek an in-seal filing of this together with the answer to interrogatory and or an in-camera on all of it. I feel as if in Judge Fabricant's 2010 order, she's very clear that she says a client who seeks to preserve the privilege has the responsibility to be careful, particularly when using a means of communication that poses known and obvious risks. Lawyers should advise clients to be careful and avoid practices that exact those risks. And then Fabricant gives a public warning to the bar in general. It says others should take note reply all is risky. So
Yeah, but this was Karen Read. As bright as she is, I don't think she reads Judge Fabricant's Superior Court orders. I don't think anybody does outside of attorneys.
is BCC. Further carelessness may compel a finding of waiver of privilege.
May find.
That was 16 years ago.
Not must find,
The
may
world
find.
and technology has advanced. We have all become more sophisticated with way to deal with it. We were also relying on an MCLE, which was written by a gentleman who was with the BBO, that says an argument could be made that privilege is now waived.
No. I have a problem with this because MCLE, for people that don't know, all the attorneys in our audience know what it stands for. MCLE is a corporation called Massachusetts Continuing Legal Education. Almost all attorneys that I know anyhow have their materials on their shelves and they read them. And before the pandemic anyhow, we would go down to Winter Street in Boston to their headquarters and take their seminars. Since the pandemic, we stay in our nice offices or even at home watching their seminars. But that's not mandatory authority. That's not a case. It's very interesting. It's very interesting. And I love their seminars. I've learned a lot from them over the years, but they themselves in their own materials say, this is material that is for educational purposes. It's not to be cited as law. And I actually found the one he's talking about. I actually found it online and I brought it up. And it specifically says that these are the opinions of the speakers and not of MCLE. And sure, that's interesting that somebody in the BBO said that this is a good argument because the BBO has to renew my registration every year, but it's an argument. That's all it is. It's not authority. It's an argument.
Basically, I see where Mark Diller is going with this, but it's true. It's not something that is concrete that the court can take as law. And I wanted to point out, Mark Diller talks real slow and it's kind of annoying, but I can see that he's trying to make a record because the court reporter is allegedly taking everything down. And I've learned to do that. And sometimes I talk really slow, just like him, because I'm used to talking so that I want the court reporter to take down my words accurately. So I talk slow. And I think that's what he's doing because otherwise he is talking really slow. And I think that it's probably because he wants a good record of it. And, this isn't going to end. I mean, I can see appeals in the future.
Well, we all have our own speaking styles, and I'm the opposite. I tend to talk too fast. I remember one of the very first cases I tried out of law school, the judge went like this, and he called me over to the bench and he said, Attorney Myers, do you know you're speaking so fast I can barely understand you? Do you think the jury can understand you? So slow down. So we all have our own presentational styles. We all need to be called on the bench occasionally. I think this is just his style. I have some other things to say about him, but that's not one of them. I think you're right. He's probably trying to make a record. And also remember that the O'Keefe's brought in this B.B. Fell, who is a dynamite trial attorney out of San Diego, California, down in your neck of the woods, more or less. And she apparently is a really dynamite trial attorney who's had some great results in court. And she also teaches trial law to young law students. So I think she's going to be the primary trial attorney. She was at this Hollywood Squares, as I call it, in the previous hearing. She didn't show up for this one, but my guess is that, he would be great on appeals. He would be an excellent attorney for appeals because he has that speaking style. But maybe if you put his style together with my style, you'd have somebody in between that a jury could understand.
The second issue, as it relates to impeachment, we have the late, great Judge Gantz, who wrote an opinion. We have Justice Kaplan, who both issued opinions. Both suggest you can't unring the bell. I identified that there were inconsistent statements in the email that was provided to me before anybody tried to recall it or advise me that that was intended as a client confidential communication. I then said, I'm not intending to disseminate it, but I do believe in arguments made that she's waived it. And I more so think it's significant that should she give inconsistent testimony moving forward, it certainly has impeachment value, which has been borne out by Justice Gantz, Justice Kaplan, Superior Court decisions that talk about the impeachment value of it. So ultimately, I stand by the position that, for starters, I believe that they have waived the any privilege that may have existed in the communication by publicly disseminating the contents of it. And then secondarily, I have every right to use it for impeachment purposes as we move forward in this litigation. Your Honor, I rest on the papers as it relates, or will answer any questions that Your Honor has.
Your Honor, may I respond?
Sure, go right ahead.
Your Honor, the notion that a litigant would be served with an interrogatory, answer the interrogatory under oath, and then somehow be deemed to have waived the privilege is preposterous. What I am arguing is, for impeachment value, there is none. And once you are able to see the email and compare it with the interrogatory answer, you will make that decision for yourself, I am confident. But if Mr. Diller served us with a motion and we served him with a motion and he attached signed interrogatory answers, or we attached signed interrogatory answers that had been served in the normal course, there's no waiver of the privilege. That's just not a valid argument. Secondly, Mr. Diller cites two cases in his brief, which is referenced today. Those cases actually stand for the proposition that there has been no waiver. The cases that he cites to, the Mirror Inc. versus O'Brien.
This caught my attention because, Yoli, as I said before, and as you know, without me emphasizing the point, the facts are the facts. You can't make up facts, but the law is also the law. Now, it's true you can argue law, but you can't misrepresent law. So I heard him say those two sites. I went back to the brief. I brought the cases up, and he's right on this point. He is right on this point. So the first one I want to take a look at briefly, folks, this isn't law school, so I'm going to go through them as briefly as I can. The first case that he cited to, let me bring it up here, is the first case that was in the O'Keefe's brief. It's Myra, INC versus O'Brien. And here's the issue. On April 30th of 2003, O'Brien served Myra with requests for the production of documents. On June 2nd, 2003, Myra's attorney provided O'Brien with 180 documents totaling 583 pages. Responsive to that request, mistakenly included in that production was a privileged December 17th, 2001 letter from Myra's current chief executive officer, William D. Curtin, to Myra's then attorney, William O'Brien. So the issue is, oops, we gave you a confidential attorney-client letter that was in discovery. Does that waive the attorney-client privilege? So now we go down to the bottom. Myra's motion to preclude evidentiary use of inadvertently disclosed privileged documents is allowed. So the privilege was not waived to the extent that O'Brien is barred from making evidentiary use of the inadvertently disclosed December 17, 2001 letter, except with the advance approval of the trial judge, predicated by the admission of false testimony. So the door was not closed entirely, but the privilege was not waived. Now, the other case, Vigor Works LLC versus White Skanska, Superior Court ruling. And here is the issue. Vigor asks the court to order WS to return or destroy two documents that Vigor asserts contain attorney-client communications and were inadvertently produced to WS during discovery. Yoli, does that sound like a familiar issue?
Yeah.
It's slightly different. It's slightly different because these two cases have to do with documents.
Well,
and
communication by attorneys and discovery documents. It's one thing when you are replying to an email, you're not producing documents.
Right.
Discovery. Right. So when you're producing documents, sometimes you mess up. You're not.
Yeah.
You're human, and sometimes a letter or something might be in there. Now, if it says something different than what a person is going to say later, or a plaintiff or a defendant is going to say later, then I think the judge has to determine whether it can be used for impeachment. So I think a motion in limine is probably going to be brought before the trial regarding this issue. That's what I think.
Probably. But the issue in this case is, what happens when during discovery, a document that allegedly contains attorney-client communications is inadvertently produced. So let's go down to the issue. I said we're not going to get into it. For the foregoing reasons, the court orders that so much of the FedEx documents and draft letter that include the 4-page email from Vigor's attorney, this is what included the attorney-client privilege material, ordered that it be returned or destroyed. So that's what the cases said, not necessarily what the O'Keefe's attorney said. They said, although the cases did go on to be truthful, the cases did go on to talk more about the issue that you just raised, Yoli. But those cases do not stand for the proposition that inadvertently sent discovery waives attorney-client privilege. They just don't. So let's go back to the hearing, which is about to wrap up.
The court found that Judge Gantz found that there was no waiver of the attorney-client privilege with an inadvertent disclosure. The case that he cites to in his brief, and he mentions as well, this is Judge Kaplan, Vigor Works versus Scansa.
That's the one we just talked about.
Kaplan finds there was no waiver.
That was really the end of the argument. They talked for another 3 or 4 minutes, but that was the end, really, of that argument. And so now the judge will take it under advisement, and he may do what Yoli just said. He may, that's an interesting thought. I hadn't actually thought of that, that the judge may well say, well, attorney-client privilege was not waived. There's no precedent for that. There's no case law that says that as black letter law, but maybe with regard to use as impeachment down the road, if there are subsequent statements in depositions or, TV, radio interviews, well then, sure, maybe they might revisit that issue. And a motion to do a motion in limine. Yeah. Good idea, Yoli.
Yeah.
So then before we move on to Karen's telephone, did you have any final comments about whether the attorney-client privilege was waived?
I don't think it was waived. I think that they reacted to it timely in terms of when she sent it. I think it was a mistake that can happen with emails. I mean, who is going to hit reply all and knowingly that her communication is going to go to other attorneys? I don't think that's what the intent was. I think it was a mistake. And I think the judge is taking it under submission, and he may say it's not waived, but maybe during trial or, we can revisit it. And I foresee a motion in limine regarding this issue.
I bet you're right. And I'm not going to bet against you for a cup of coffee because I think you're probably, I hadn't actually thought of that option. I thought the judge would just rule one way or the other on both of the questions in the hearing. But
even if he does rule that it's not waived, period, I think Karen Read's attorneys will bring it up on a motion in limine again.
Yeah. Okay. Good point. Hadn't thought of it. Okay, so now as you see in the photo in front of you, Karen Read was back in Norfolk County Superior Court again the same week, 2 days later than the hearing we just saw, which was on Zoom, but the judge was in the Plymouth County Superior Court in Massachusetts. So here is Karen Read on the steps of the Norfolk County Superior Court. What is she doing back there? Well, this is the argument about her phone. This is the argument about her phone. And this goes way back to, I believe, January of 2024. I've got to get out my cheat sheet, Yoli. Way back in January of 2024, Karen Read's phones were seized pursuant to a warrant. In August of 2025, Special Prosecutor Cosgrove brought a motion to search the phones in actually backing up to March of 2024. Cosgrove went to a grand jury trying to allege that Karen Read and Aiden Kearney, Turtle Boy, were intimidating witnesses and conspiring to intimidate witnesses. He failed to get a grand jury indictment. And even though he failed to get a grand jury indictment after trial 2, and Karen Read is acquitted of all major criminal charges back on June 18th of 2025, Cosgrove is at it again. Now, there's been a very recent order by Judge Krupp that the phones should be returned. Judge Krupp said, no, you can't. And this was in a different case. It gets confusing. But in a different case, Judge Krupp said, no, you can't go into the phones. It's been 19 months. And moreover, give her phone back. Well, Cosgrove appealed that. The appeals process is going on. All of this was argued in the Norfolk County Superior Court in Dedham. After the hearing in Norfolk County Superior Court in Dedham, Karen's attorney on this issue, Benjamin Urbalis, stopped and talked to reporters outside and said, it's been so long, there's really no need to continue a witch hunt.
Well, I think we put forth everything that we could. We made our argument in court. I believe Ms. Read's been entitled to her cell phones. So the prosecution filed a last-minute motion to stay Judge Krupp's decision to deny the search warrant. They filed that yesterday. It's been 2 years. So we're hoping that Judge Tulin carefully considers our arguments and our filings and orders the phones to be returned immediately.
But the judge didn't order the phones to be returned, though, right?
They want to get her for something. They've already failed once in front of a grand jury. They presented evidence trying to say that she conspired to intimidate witnesses. They failed. They couldn't even, this wasn't even a ham sandwich. They couldn't even indict her. So now they're trying to do what they can to get her on something else. So we'll see what happens. I expect that Judge Doolin should rule in our favor, and hopefully Ms. Read can move on with her life now.
So it gets a little bit more complicated than that. There is an appeal to Judge Krupp's order in a different case that's going up to the SJC. And will this court allow Karen Read's 2 phones to be returned to him, or will he go along with what Robert Cosgrove, the special prosecutor in the Aiden Kearney case, is arguing that, well, let's just see what the Supreme Judicial Court does, which could take a long time.
I think Cosgrove thinks that something's going to happen to the phones during the appeal, and that they shouldn't be returned to her because something could happen to them. And if the appeal is granted, then the phones could be tampered with. But I mean, I guess I understand that, but at the same point, I don't understand what they're trying to do with Karen Read. I feel like they just can't let it go they just have a fixation on her. And
well, here's proof of that in this next video cut that I have of Special Prosecutor Robert Cosgrove was talking to a very good Boston reporter by the name of Christina Rex. She works for the CBS affiliate WBZ in Boston. And Cosgrove said, no, we're not trying to get her. But he said it in these words.
I don't think the Norfolk District Attorney's Office wants to get Karen Read or anybody else.
Special Prosecutor Robert Cosgrove confirms he does want to investigate Karen Read for another crime, and he believes there could be evidence on her cell phones.
This is a separate investigation into a separate crime. It's a decision that I made as the special prosecutor without consulting with anybody in the Norfolk DA's office.
That crime again being witness tampering or witness intimidation?
Yes.
Does that make any sense to you, Yoli?
no.
We're not trying to get her, but she may have committed another crime and it's on that phone.
So then you are trying to get her for that crime.
That's what I'm saying. We're not trying to get her, Mr. Myers, we're not trying to get you, but there might be stuff on your phone that we have to see if you committed any other crime. I mean, maybe she stole a package of chewing gum at CVS. I doubt it, but I mean, the whole thing is ridiculous. So I don't know. I really don't know. The other thing that boggles my mind is the seizure of the phones goes all the way back to January of 2024, which is over 2 years ago now. And why, they have all these alleged Celebrite and other experts. Why didn't they just download the contents of the phone and give it back to her? That in this era, 2022, 2024, 2026, that is a possibility. You just go into the phone, you peel out all the contents of the phone, you give it back to her. That is technologically absolutely possible without any question. So I don't
guess
know why.
there was never a request to do that. There was a request to get the phone, but never to seize the contents.
No, that's right.
I don't get it. I don't get it. I don't get it why they wouldn't want into her phone contents in the trials that she had. I mean,
well, wait a minute. If the district attorney was serious about going to the grand jury on this conspiracy between Turtle Boy and Karen Read, and they had both of their phones, why didn't they get a search warrant to go into the phones way back then in March of 2024? Why didn't they do it back then? That makes no sense.
This is wild.
It makes no sense. I mean, that's what it's. I mean, if they can afford, $488,000 to pay the special prosecutor, and if they can pay $500,000, it was more than $500,000 that they paid to your Blue Man Group experts, which I forget the dollar amount now. I want to say $800,000.
No, I think it was less than that.
566. I don't remember the number, but the point is, they had millions of dollars to prosecute the Karen Read case twice and lose twice, with the exception of the DWI charge. Why didn't they bring a motion to get into the phone back in January, February, March of 2024? It makes no sense. But anyhow, we have viewer comments this week. And let's see, we have to say goodbye to the reporters in Dedham and say hello to our comments, which this week are on our Enrique Delgado-Garcia episodes.
You can take the odds.
Oh, okay. All right. Christy Mitchell says, thank you, Attorney Myers and Attorney Medina. Your guest was fabulous. And that was the attorney Michael Wilcox for the Delgado-Garcia family. Your guest was fabulous. I agree with all of you. They don't need to box. However, I wish the family of the young trooper good health, and let's hope they get justice for him. And I am very impressed with Attorney Myers for his work in this very sad case. I had nothing to do with it. I'm just a reporter. I mean, thank you for the thought, but all I'm doing is conveying information that I see. But thanks anyhow.
This is Fan of the Truth. It says, excellent episode. Corruption displayed in Karen Read persecution was silenced by those in power. They have tried to silence the stunning corruption in Sandra Birchmore and continue, notice no state charges. Enrique's case should have stopped the MSP union in their tracks, member on member crime, but they resumed their tone-deaf stance. Jen Penton's crimes extend to her corruption in covering up Sergeant Quigley's DUI causing a death.
Yeah, we should get more into that. I was disappointed that our episode on the Enrique Delgado-Garcia case didn't get more viewers. I am told and understand that the algorithm doesn't like it when you try something new. They have you down for all the things you've done in the past. So two things out of that. We will continue to look at this in the other cases. Jen Penton. There was an article in the Herald today, the day we're recording this, that all of the officers, the 4 state troopers who were indicted, have now been suspended from the Mass State Police. We already had our topics picked for today, so Yoli, I think we should do more on these 2 cases.
Mm-hmm.
Okay, Grand Ren 2. I'm pissed too, Yoli, but happy to see movement towards justice for this family, because you said that this whole Delgado-Garcia case pissed you off, didn't you?
It did, because, I mean, do they make it harder for certain people to get to compete? Like, I don't know. It's just, it seems to me like sometimes things are harder for people who are minorities who are here legally. I mean, they're not, and I wonder about that. And I know that there hasn't been any information of that he was targeted because of his race or because of, anything else other than just, is this something that is like unconscious that people just make it hard? Because I've seen other cases like this, and usually they're either Black or Hispanic and is it coincidence or what is it? And it kind of pisses me off because it's like, what did this guy do to anybody? I mean, they put him in there with somebody who is probably a lot more skilled, and look what happens.
It's hard to know. It's really hard to know. It's really very hard to know. But you're in California, and I think the same thing's true from what I know about California. If I'm wrong, please let me know, as you have before. But many of the Massachusetts cities are heavily Latino. And I was in North Andover, Massachusetts for 27 years, which is in Greater Lawrence. And I loved all of my clients who were Latino. One of the failures in my life is the failure to learn how to speak Spanish fluently. I can speak it a little bit, but many of the cities in Massachusetts, including Worcester, are heavily Latino. So there's no need for that. There's just no need for that. Number 2, your turn.
Monique Unfiltered. It says, what a complete sad state of affairs. Not really sure how the culprits can actually look at themselves in the mirror. Imagine losing a son, brother, grandchild like Enrique. A good-hearted, decent young man. It's deplorable. It is. It's deplorable.
No question. No argument. Okay, our number 1 comment this week is from Smart Towel RG400. We need major changes to law enforcement and how district attorneys' offices are policed. We need more charges and faster charges. An everyday citizen commits a crime, it's investigated and charged within a few days. A cop commits a crime on camera. It takes 2+ years to announce if they will charge or not. Usually not. And I would encourage people to go back and take a look at our Enrique Delgado episodes. I'll put them both down in the details section. The first one, which is the basic background and the fact of 4 indictments. Then the second one that we did, we interviewed his family's attorney, Michael Wilcox, who had some really good points along the lines of, he made a lot of good points, but one that stood out to me was Massachusetts needs an overall look at the state police, and it can't come from inside. The new colonel, Mr. Noble, has said that he's going to do what he can, and he'll look into everything, and there'll be reforms. But you know what? That's internal, and he was a state trooper down in New Jersey. Law enforcement is all well and good, but reform's not going to come from the inside. It has to come from the outside, and not from the political stuff of people standing up at the State House and saying, oh, we're going to do this, we're going to do that. No, it needs to be a citizens panel, needs to be people that are experienced in law enforcement, needs to be experts who know about, how to run an investigation. It needs to be a lot of different folks from a lot of different backgrounds looking into it outside of the political BS on Beacon Hill.
And also, too, the other thing about this Delgado case is this the case of where they just want to be macho and they're just, that kind of mindset needs to change. They're in training, they're not competing. And, this case bothers me on so many levels.
Well, I'm sorry to bother you. With it. No, it is a horrible case. I don't mean to demean it at all. It's a horrible case, and it never ever should have happened. And it's just, I don't know. It is depressing to think about, but maybe we can hope that there'll be change at some point. Although, as I've said before, and you and others have gotten down on me for it, Massachusetts just has such a long history of corruption that I don't know. Again, we do not sell merch. We do not ask you for super chats. I don't ask you for money. I don't break off in the middle of my podcast and try and sell you life insurance, or I don't even know what people try and sell. All we do is we ask you to subscribe, and it's free, as Lucky and all of his buddies from the Karen Read trial are going to explain to you.
Pay for a subscription?
I do not.
Ask it differently. I'm going to allow that.
Well, you know now because you follow. You pay for a subscription?
I do not.
Did you get one for free?
Yes. I was not paying to any social media.
All right, Mr. Brennan.
Sorry, I have just a few more questions.
It's denied.
I was not paying to any social media.
Okay.
Yoli, at the end of these episodes, we ask people to show us that they've been with us all the way through by dropping an emoji. Do you have any ideas for an emoji this week?
A phone.
A phone. Okay. A phone, because that's how you send an email, right?
Well, you
Or
can
click
computer.
I know, but everybody uses their phones now. People laugh at me because I'm always on my computer. What are you doing on your computer?
Yeah,
my intern edited the whole episode on her iPhone, and I don't know how to do that. I wish I did, but I don't know how. But a lot of people now spend their entire life on their phones and do everything. But okay, a phone. All right. Yoli, thank you so much for providing, some insight that I didn't have in these cases. And until we meet again, have a good one. Whether you are in the grocery store, the gas station, or anywhere else, please remember to be kind to people. You don't know what they're going through. And the same goes for our comments section. We want you to comment, but be nice, be kind, be positive if you can. And thank you for watching. Be sure to like and subscribe. Have a good one.